All right, counsel, it's my understanding the attachments have now been received as exhibits to this hearing. I will note some of them. It's appropriate to impound insofar as they relate to grand jury testimony and some other non-public information, including some impounded pleadings. So I'll determine what will be public and what will not at the conclusion of the hearing. Is there any further evidence to be offered?
Yes, Your Honor. The Commonwealth would like to call witness at this time.
And who is that?
Mr. Hagen.
All right.
You solemnly swear that the testimony you shall give to the court in the matter now pending before the Commonwealth and the defendant shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Yes, sir.
And Mr. Lee, I take it for purposes of this motion, you are lead counsel.
Yes, Your Honor.
All right, you may inquire.
If you wouldn't mind, could you just introduce yourself for the purposes of the record and spell your last name?
Certainly, my name is Patrick Hagen, last name spelled H-A-G-G-A-N.
And Mr. Hagen, can you tell us by whom you're employed?
I am employed by the Suffolk County District Attorney's Office.
And how long have you been with the Suffolk County District Attorney's Office?
Approximately 22 years.
Okay. And can you tell us what your present title is in the Suffolk County DA's office?
My present title is the First Assistant District Attorney.
And how long have you been the First Assistant District Attorney?
I believe since 2011.
And what are your general responsibilities?
I oversee the legal side of the office. I supervise approximately 150 lawyers as well as approximately 250 total employees. I make all major decisions relative to plea agreements, proffers, dispositions, and various other administrative tasks.
Where were you assigned prior to being named the First Assistant?
Prior to being named the First Assistant District Attorney, I was the Chief Trial Counsel. I've been named the Chief Trial Counsel in 2005. Prior to being named Chief Trial Counsel, I had been a member of the Homicide Unit. I believe I was in the Homicide Unit from 2001 until 2005. Prior to that, I was in Major Felony Units, District Courts, supervisory positions in District Courts as well.
Mr. Hagen, did there come a time in July of 2012 when you were assigned the case that is an issue in court today?
There was. I was assigned to this case on July 16th of 2012, the morning that it happened.
And have you been the attorney primarily assigned to the investigation and prosecution of that case from that day?
I have been.
At some point, did you begin a grand jury investigation into the facts and circumstances surrounding the shooting on July 16th of 2012?
I did. We had actually two different grand jury investigations, one beginning in July of 2012 and a subsequent grand jury that began on or around July of 2013.
In March of 2014, did there come a time when an individual by the name of Brian Murphy came to the Suffolk County Grand Jury to give testimony regarding what he knew in connection with this case?
That is correct.
All right. And when Mr. Murphy came to the grand jury in March of 2014, did he come with counsel accompanying him?
He did. He came with attorney Thomas Butters, a very well-known, reputable attorney in the city of Boston, who mainly handles criminal matters.
And what was your understanding as to why Mr. Butters was representing Mr. Murphy in the grand jury?
He was representing Mr. Murphy's interests as a witness to the grand jury. I think he was also representing him to the extent that it may have been conveyed to Mr. Butters that there were some affidavits that were already submitted by Mr. Murphy. And I think Mr. Butters was just protecting Mr. Murphy's interests.
Now, at some point, in the months leading up to March of 2014, had you had, strike that, at some point were you, did you have some dealings with Mr. Hernandez's predecessor counsel to the counsel he has currently?
That's correct. I had multiple interactions, communications, conversations with Mr. Hernandez's original attorneys, that being Mr. Rankin and Mr. Sultan, as well as subsequent conversations with Mr. Butters eventually.
Okay. And the conversations that you had with Mr. Rankin and Mr. Sultan, did they include discussions about your intention to call Mr. Murphy to the grand jury?
That is correct. Starting in November of 2013, I approached Mr. Rankin, advised him of our interest in calling Mr. Murphy as a witness. It was my understanding that it was his sports agent at that time. We had checked into Mr. Murphy and found that he was no longer a practicing attorney. When I brought that up with Mr. Rankin expressed some concern about him being a member of the defense team. Mr. Rankin suggested to me that he became a member of the defense team on or about the time of the Odin Lloyd homicide on June 17, 2013. He indicated that there could be some issues with that. And over the next number of months, Mr. Rankin and I had various conversations and in essence negotiations as to how the Commonwealth could get the information we needed from Mr. Murphy that we felt was not protected by the attorney-client privilege.
And were you and Mr. Rankin able to successfully come to an understanding or an agreement as to how that would be done?
Sort of. Initially, our agreement was that perhaps Mr. Murphy could provide affidavits that would answer all of the questions that the Commonwealth sought from Mr. Murphy without potentially getting into anything as far as a defense team member as of June 17, 2013. There were two affidavits that were submitted. The first was in January of 2014. Upon reviewing the affidavit, I was dissatisfied, particularly with the date range that was placed on the information about Alexander Bradley. It was my determination, which Mr. Rankin did not disagree with, that Mr. Murphy was not a member of the defense team, at least relative to the shooting of Alexander Bradley. So we had conversations about the date range. Mr. Murphy eventually changed the affidavit to remove the date range, which I believe was June 17th, ostensibly the date that he became a member of the defense team. There were conversations additionally with Mr. Rankin about the fact that his affidavit, particularly paragraph 5 of the affidavit, seemed to be completely inaccurate based upon the text messages that we had at the time and that Mr. Rankin and Mr. Sultan had at the time as the defense on the case of the murder of Odin Lloyd.
And at some point did you determine that instead of relying on the affidavits that were submitted by Mr. Murphy, that you would then intend to call Mr. Murphy to the grand jury?
That's correct. For a number of reasons, we felt there was more information we needed. Additionally, I was concerned with the current form of the affidavits. In my opinion, I could not introduce to the grand jury because they were inaccurate and potentially perjury. Again, I didn't suggest that Mr. Murphy had perjured himself, but instead, again, paragraph 5 in both affidavits was completely false. And under the possibility that Mr. Murphy could take a Fifth Amendment privilege, we did begin to draw up documentation relative to immunity for Mr. Murphy if that became necessary.
And then at some point did you seek leave of court to issue a subpoena to Mr. Murphy?
We did. We started again with the process under Rule 3.8 of the ethical rules to subpoena him as an attorney, but again, once counsel for the Commonwealth determined that he was not a practicing member of the bar, the motion for an out-of-state subpoena was brought to a Suffolk Superior Court judge. The judge was advised of the status of this individual as an administratively suspended attorney, and normal process went for his appearance in the grand jury.
Now, when Mr. Murphy and Mr. Butters appeared at the grand jury, did you have a discussion with them, generally speaking, about the parameters or the limits of the questions that you intended to ask Mr. Murphy in the grand jury?
We did. We had a rather extensive conversation about that, and also Mr. Butters and I had prior phone conversations about those facts prior to Mr. Murphy coming to the grand jury.
Okay. And was one of the things that you discussed prior to the grand jury with Mr. Butters a clarification, if you will, of what you intended to ask Mr. Murphy?
That is correct.
Can you tell us in summary the nature of the discussion that you had on the day that Mr. Murphy came to the grand jury involving Mr. Murphy and Mr. Butters?
Certainly. It had come to my attention through Mr. Butters for the first time. Again, we were under the assumption that Mr. Murphy had become a member of the defense team relative to the Odin Lloyd litigation. Mr. Butters did make clear that there were some things Mr. Butters and Mr. Murphy were concerned about relative to him potentially being a member of a defense team as far as the Ropes and Gray representation related to the Alexander Bradley shooting. So Mr. Butters and Mr. Murphy and I had a conversation about that. Mr. Butters made clear, Mr. Murphy affirmed as well, the fact that as long as we didn't get into anything that was relative to Mr. Murphy being present for meetings with the Ropes and Gray attorneys, that the rest of the questions that were presented to Mr. Murphy and to his counsel, Mr. Butters, that those were appropriate. And in particular, there was a conversation prior to the grand jury where I showed a copy of the text messages, including the text message referencing dropping the phone off. And I asked Mr. Butters and Mr. Murphy present there whether or not they felt comfortable answering that question without of what that meant, without disclosing any what they felt were attorney-client conversations at Ropes and Gray. Both Mr. Butters and Mr. Murphy answered in the affirmative that they could answer that question without disclosing meetings or conversations at Ropes and Gray. And I specifically told them that I was going to ask that question.
Okay. And that reference that you just made was to grand jury exhibit number 77. That's the text messages first between Mr. Bradley and Mr. Hernandez, followed by text messages between Mr. Murphy and Mr. Hernandez. Is that correct?
That's correct.
Okay. And in effect, with respect to the text messages between Mr. Murphy and Mr. Hernandez, was it your intention to simply ask Mr. Murphy to give some context to the references made in the text message regarding a cell phone?
Exactly. And I specifically asked him, can you answer that question, what that means, without getting into any what you think is attorney-client material?
And when you say what that means, by the word that, you mean the text, the actual substance of the text messages, correct?
Exactly.
Okay.
And it was specifically the substance of the text message that said words to the effect of, I just dropped the phone off.
Was it your understanding in these discussions prior to Mr. Murphy actually going into the grand jury that one of Mr. Butters' chief concerns was that you not broach the topic of any meetings at which Ropes and Gray was a participant with Mr. Hernandez and Mr. Murphy?
That's correct. And keep in mind that Mr. Butters and I had prior conversations, and I told Mr. Butters, look, we're not conceding that there is an attorney-client relationship, even if Mr. Murphy is there, but there's no need to litigate that. We can agree that we're not going to ask about that. And Mr. Butters was clear, and I've known Mr. Butters for years, and he said, look, if you get into anything about meetings at Ropes and Gray and what was said, I'm going to jump in. And I said, absolutely, Tom, I understand that, and I agree.
Okay. And with that, did you ask then, did you check with Mr. Butters and Mr. Murphy with whether the questions you intended to ask were satisfactory to them, at least in terms of the scope?
Absolutely.
And to your recollection, Mr. Hagen, did you ever ask a question in the grand jury that specifically referenced Ropes and Gray?
No.
Now, Mr. Hagen, you said at some point, and I'm now taking you back to the time frame when you had some discussions with Mr. Rankin about whether the information you were seeking from Mr. Murphy could be satisfied by way of affidavit. Do you recall that time frame?
Yes.
Okay. And there were two affidavits eventually filed by Mr. Murphy in an attempt to capture the information that you deemed was relevant or important to him, correct?
That's correct.
Okay. Now, Mr. Hagen, those are two sets of affidavits that I've handed to you, correct? Do you recognize those?
I do.
All right. And one is a January 2014 affidavit from Mr. Murphy, and the other is a February 2014 affidavit from Mr. Murphy, correct?
That's correct.
Okay. And can you tell us whether there are any differences between the first and the second, that is the January one and the February one, and if so, what the changes are or the differences are?
Yes, I believe the only difference is in paragraph 5, where paragraph 5 of the January 21st, 2014 affidavit has a date restriction of June 17th, 2013, whereas the subsequent affidavit that was submitted by Mr. Rankin, purportedly or ostensibly from Mr. Murphy, removes that date restriction, and that was based upon conversations I had with Mr. Rankin.
Okay. And is it fair to say that the date was removed basically at your request?
Essentially, I expressed to Mr. Rankin my concerns, one, whether or not there was any attorney-client information that could come out after June 17, 2013 that would be relevant and not covered by the attorney-client privilege. I didn't want to limit it. Additionally, I did express to Mr. Rankin some concern about the accuracy of Mr. Murphy's representations, particularly in light of the text messages that I had.
And those text messages that you had actually predated June 17, 2013, correct?
That's correct.
As far as, other than the, and now referring you to paragraph number 5, other than the date restriction of June 17, 2013, is the first sentence in each paragraph, that is the January paragraph 5 and the February paragraph 5, identical?
Yes.
Okay. And what did you understand the first sentence of paragraph 5 to mean?
I had understood that to mean any communications. Again, I'm dealing with a lawyer, Harvard-educated lawyer. I would think communications, particularly in today's modern age, would include text messages, voicemails, emails, if anyone uses those anymore. But I understood communications to mean all communications of any type.
Not simply restricted to the underlying facts of the Alexander Bradley shooting, correct?
That is correct.
So in your mind, that sentence encompassed also any communications that might have had to do, for instance, with threats by Mr. Bradley to sue, threats by Mr. Bradley to take Mr. Hernandez's money.
Absolutely.
That, in your opinion, would have been covered by the first sentence of paragraph 5 in either one of the affidavits.
Absolutely, and keep in mind that we have an ethical obligation to disclose to the grand jury any exculpatory evidence as well. And in my mind, any text messages from Alexander Bradley threatening or saying anything that could be used to later impeach him would be something I had an ethical obligation to obtain and submit to the grand jury.
Thank you, Mr. Hagen.
Thank you.
Mr. Sullivan.
Thank you, Your Honor. Mr. Rankin never told you that he represented Mr. Murphy, correct?
Correct.
He never held himself out to represent the interests of Mr. Murphy.
Not specifically, but he was the primary negotiator, so to speak, for whether or not we would get to Murphy.
He never told you he was the lawyer for Mr. Murphy.
Never told me he was the lawyer for Mr. Murphy.
Your understanding was that he was not the lawyer for Mr. Murphy.
My understanding from Mr. Rankin was that Mr. Murphy was ostensibly or purportedly part of the legal team representing Mr. Hernandez. And in this...
That was my question. You didn't understand Mr. Rankin to be Mr. Murphy's lawyer, not part of a team or anything. Your understanding was that Mr. Rankin did not represent Mr. Murphy.
Quite frankly, I didn't know one way or the other. It did cross my mind that at a hearing that I thought was potentially possible, where Mr. Murphy would be asked to, in essence, testify or determine whether or not it was covered by the attorney-client privilege, I did contemplate that it was possible Mr. Rankin could be representing him at that. I wasn't told that by Mr. Rankin, but that was going through my mind.
Right. You were not told that at all?
I was not told that.
No letters to that effect?
No letters to that effect, but everything regarding Mr. Murphy was sent directly to Mr. Rankin, including a letter from me.
No letter saying, signed, Charlie Rankin on behalf of Brian Murphy.
No, but emails from Mr. Rankin saying he got it, he's going to submit an affidavit, he's this and that. He was basically the mouthpiece for Mr. Murphy.
And in those emails, nothing that said, well, I'm going to give you something from my client.
Never used the word with my client. That's correct.
Now, you mentioned a series of conversations right before the grand jury testimony. Do you have that in mind?
Yes.
And these were conversations with Mr. Butters,
Correct?
conversations with Mr. Murphy.
Correct.
Mr. Hernandez's lawyers were not part of these conversations. Correct?
That is also correct.
So in these conversations, when you spoke about the scope of prospective questions, Mr. Rankin or Mr. Sultan were not there to give their opinion as to the scope of those questions, correct?
That's correct.
And you do understand that the privilege is Mr. Hernandez's privilege, correct?
Absolutely.
You made some representations about Mr. Rankin and what he believed or thought he believed. I want to draw your attention to this litigation and before this court. Indeed, you do recall that in this court, Mr. Rankin objected that the Commonwealth had only learned of the existence and whereabouts of the phone by violating the attorney-client privilege that extended to Murphy. You recall those objections?
Subsequent, absolutely. Yes.
And you recall this judge stating that this isn't the time for that argument, but we'll get to that later.
Agreed.
You further agree that you learned about the whereabouts of the telephone from the grand jury testimony provided by Mr. Murphy.
I disagree.
What witness provided you that information?
Not a witness.
What document provided you that information?
The text messages in combination with conversations with lead prosecutors from Bristol County.
What are their names?
Bill McCauley, the first assistant.
What did he tell you?
Well, again, we'd had multiple conversations in the context of providing the text messages to Suffolk County to assist in our homicide investigation. We had some conversation about the text messages. Mr. McCauley said, you do realize when you look at that text message, clearly Aaron Hernandez is referencing dropping the phone off at Ropes and Gray. I think one of the missing phones of Mr. Hernandez is at Ropes and Gray, which caused me to look at it a little more closely. And quite frankly, Counselor, I thought the language spoke for itself. Dropping the phone off at the lawyer's office, we know who's being represented by Ropes and Gray. So even before Mr. Murphy came to the grand jury, I certainly felt that I had information to believe the phone was at Ropes and Gray.
When did you have this conversation with Mr. McCauley? Approximately.
Had to have been in 2013, I would say summer of 2013, perhaps. I don't have exact recollection, sir.
Did you take notes?
Of my conversation with Mr. McCauley?
Yes.
No.
Now, with respect to your conversations with Mr. Butters prior to going into the grand jury, did you take notes of those conversations?
I certainly had a notepad out, but I don't think I took any notes of the conversation. I think it's sometimes distracting to do that, particularly when you're talking to a witness. So I don't recall taking any notes.
You said you had a notepad out. Do you still have that notepad?
I don't know.
Also said you spoke with Mr. Murphy. I assume Mr. Butters was present as well. But
Yes, all the conversations I'm referring to, there were a number of people present in the room.
did any other people take notes during those conversations that you saw?
I don't know if notes were taken, but I know my co-counsel on the case, Ms. Anderson, did provide me later with some of her typed up, I don't know if they were her memories or typewritten versions of her notes. She did provide me with something.
And you still have those notes?
I believe we do.
How soon can you produce those notes?
By the end of the day?
Ms. Anderson, did anyone else, to your knowledge, take notes?
The lead detectives were present. I have no recollection whether or not they took notes, but I do believe we turned over their notes in the course of discovery, but I can certainly look into whether or not any other notes of that conversation exist.
Before today's hearing, did you disclose to anyone that there were some sort of relatively contemporaneous notes taken during these conversations that you described?
Which notes are you referring to?
The notes that you're going to get me by the end of the day.
Well, those would be notes taken by Attorney Anderson. So I was aware of the notes taken by Attorney Anderson. It's my sense that those notes are not discoverable. They're work
Did
product.
you say those were notes, or did you say that was a memorandum?
Oh, great point of clarification. I don't know if they were notes. I know I received some type of document from Ms. Anderson just with her. Again, I don't know if they were her impressions or thoughts or memories or notes. So I should clarify that. That's what it was.
Those you're able to produce by the end of the day.
Well, again, as long as after determination we feel they're not work product. Again, I don't recall exactly what's in that document. But again, if it's Ms. Anderson's impressions or legal thinking, we probably have to redact portions of that.
And you've also represented that you will check with respect to detectives' notes, whether those have been turned over to us.
Certainly.
Which detective?
I believe my best recollection, the detectives in the room were Sergeant Detective Sullivan, Detective McIsaac, and Detective Cummings. Although I could be wrong, one of them may not have been there.
Indulgence. The information about the Bristol County District Attorney, is it McCauley?
William McCauley.
Macaulay. With respect to that conversation, did you include that in any affidavit or any other writing in support of a search warrant for the information?
No.
Did you disclose that to anyone else?
Disclose what?
Did you ever tell anybody about this conversation? You ever talk to anybody about this conversation?
Oh, I believe so. I believe we had multiple conversations with the detectives, other counsel working the case.
Which detectives?
The same investigating detectives.
Sullivan?
That would be Sullivan, McIsaac, Cummings, and Monroe at the time.
You told each of them that?
Well, I don't know if I told each of them, but certainly there were group discussions where we were talking about different aspects of the investigation and attempts to get certain evidence, and I'm sure that came up on multiple occasions.
And which, you mentioned some lawyers?
Well, that would just be Miss Anderson, who was co-counsel on the case. It's possible Miss Smith was present at one or more of the conversations. I don't have a recollection, but she was on the case initially when it happened and then came back about a year ago.
And when did this conversation happen relative to the grand jury testimony of Mr. Murphy?
Now you say conversation in the singular. Which conversation are you referring to?
Conversation with Mr. McCauley.
Oh, it was prior to the grand jury. It was prior to the subpoenaing in the grand jury of Mr. Murphy.
How long, how much? Just order of magnitude, a month before?
I'd say
More than a month before?
a few months before, because I know the back and forth between Mr. Rankin and I basically took all the way from November, when we first started discussing it, until Mr. Murphy eventually testified in March. So I know the conversations with Mr. McCauley, at least the initial conversations, were prior to November of 2013. But it's not unlikely that we may have also had subsequent conversations in the ensuing months.
Can you make these conversations from where? Your office? Make these telephone calls from your office?
Usually telephone calls, yes. I believe we had one group, perhaps even two. I have a recollection of one group meeting with the prosecutors and the investigators from Bristol, where we went over some consistent information that we were looking into.
And did Mr. McCauley make any representations to you with respect to how he came about this information?
Now, overruled.
Well, I don't recall him specifically telling me, but it was clear that they got the text messages from a phone dump of Mr. Hernandez's phone.
No direct evidence, in other words. In other words, no one told him. When you had the conversation with Mr. McCauley, it's fair to say that nothing about any of the conversations were of the nature that I have a witness who saw, or a witness who told me that Mr. Hernandez dropped his phone off at the Ropes and Gray law firm.
It was more of a reasonable inference, Mr. McCauley saying, here's the text messages, here's what we know. Clearly the phone's at Ropes and Gray.
Well, was that based on reading the text messages and telling you, take a look at them, it's clear, or was it based on other information?
I believe it was mostly the former, the text message and making a determination from the text message.
So that I understand your position. Your position is that you knew of the location of the phone without regard to anything Murphy said, because the message itself permitted that inference.
In my mind, yes.
And to be clear, in your mind, so that was not the basis of the affidavit to support a request for a search warrant.
Absolutely not, no.
Text message said dropped off the phone.
Agreed,
Correct.
agreed.
The text message did not say drop off the phone at R&G, correct?
No, but there may, I should clarify, I believe there was a subsequent text from a Miss Savannah Wall that may have referenced Ropes and Gray that we received. I should clarify that. There's that same day, there's some text message between Mr. Hernandez and Miss Wall.
Fair enough. I'm focusing you on the text messages about dropping off the phone. In that exchange, dropped off the phone, there was no reference to dropped off the phone at Ropes and Gray, correct?
In that message, no, but Miss Walls, yes.
No reference to dropped off the phone with Mr. Feet.
No,
No reference to dropped off the phone with Mr. Jones.
no.
No reference to dropped off the phone at my lawyer's office.
I think he said at lawyer's office, I think, in the text message.
Well, we're going to have to narrow to the dropped off the phone line is the message I'm talking about. That sentence was not completed with the lawyer's office, correct?
Well, he said the word lawyer's office, I think.
Yeah. Right. Well, the record will speak for it.
Right.
Record will speak for itself. But your testimony is that you drew the inference from dropping off the phone and the fact that you knew who his lawyers were. That's how you came to that information.
That text, knowing who the lawyers were, and Miss Wall's text.
Okay. Final question, as your basis for seeking the relief you desire, you rely on the grand jury testimony of Mr. Murphy as evidence to support the relief you requested.
And when you say relief that we requested, are you referring to our motion for the cell phone or our search warrant affidavit?
Well, the search warrant affidavit.
I believe we relied on all three. We relied upon the text message and the text message from Mr. Hernandez, the text message from Ms. Wall, and Mr. Murphy's grand jury testimony.
That Mr. Murphy's grand jury testimony was part of the evidence that you used to justify the search warrant. That's a fair statement.
It was part, yes.
No further questions.
Anything further, Mr. Lee?
No, Your Honor.
And just out of curiosity, who is Samantha Wall?
I apologize, Your Honor, for not clarifying. Samantha Wall, traditional spelling of both names, is an employee of Athletes First. She works directly for Mr. Murphy, and she was, in essence, one of Mr. Hernandez's close handlers from Athletes First.
And you're saying that there was a text to her around the same time as the text that Mr. Murphy testified about?
I can't recall if it was a text to her or from her, but some reference to going to ropes or something about the dropping of the phone off.
All right. That's not part of the record evidence that's been offered here, is that correct?
If it's not, Your Honor, I certainly would recommend that lead counsel for the Commonwealth make it part of it.
Your Honor, it is part of the record. It's part of the search warrant affidavit. It was one of the exhibits. And I believe the paragraph can be found on page 21 of the affidavit.
All right. Anything further?
No, Your Honor.
You may step down.
Thank you,
Watch
Your
your step. Commonwealth, any further evidence?
No, Your Honor.
Mr. Sullivan, anything further?
We're ready to proceed with argument at Your Honor's discretion.
All right. Well, the evidence then closes. Let me hear you.
Thank you, Your Honor. We submit that we have met our burden with respect to the attorney-client privilege being pierced in order to effect a search warrant to secure the telephone at issue. As Your Honor knows, in Massachusetts, the attorney-client privilege exists on at least 3 registers, and these are the 3 registers that I'm going to argue are impacted here. The first is the attorney-client privilege may be present if an individual is the attorney in fact for a client. The second is if an individual is a representative of a client. And the third is if an individual is a representative of an attorney. And I will go through each in turn. The first, the attorney in fact. I'm not going to spend a lot of time on this one, Your Honor. We believe that Mr. Hernandez reasonably believed that he was getting legal advice with respect to the threat of civil lawsuit. The second he sent the threatening messages to Mr. Murphy. From my research, it appears that there is no Massachusetts court that has directly addressed whether an attorney's lapsed or inactive Massachusetts bar membership in and of itself vitiates an attorney-client privilege. There are some cases that are suggestive of the same, but there is no direct case in Massachusetts that so holds. Courts in other jurisdictions that have directly considered the issue have concluded that a lapse in bar membership in fact does not vitiate the attorney-client privilege. particularly when a client reasonably believes that he is receiving advice from a lawyer. You heard testimony that Mr. Murphy graduated from the Harvard Law School, practiced at an elite firm here in the city.
Do I have any evidence that Mr. Hernandez knew about that?
We will ask the court to draw an inference that Mr. Hernandez knew about the background of his agent with whom he had a 5-year relationship. The second is that even if the court were to decide that Mr. Murphy was not the attorney in fact, it is clear that Mr. Murphy is or was the representative of the client. So in Massachusetts, the attorney-client privilege also applies in communications, and I'm quoting the Massachusetts General Evidence Section 502B4, that the attorney-client privilege applies to communications, quote, between the client and the representative of the client. Continuing the quote, a representative of the client may include the client's agent or employee, with a stress on the word agent. It is without dispute that Mr. Murphy was the agent of Mr. Hernandez. Now, if this court determines that Mr. Murphy was in fact the agent of Mr. Hernandez, and we submit that is not beyond dispute, the legal test that the court has to answer is whether those communications between agent and client fall within the scope of the employment or agency relationship. And this is found in the Jensen case, Mass Court of Appeals, 57 Mass Court of Appeals, 8/11/2003. So, determine that there's an agency relationship. If the answer to that question is yes, the court then must decide, well, were these communications within the scope of the agency relationship? Now, that question was answered with Mr. Murphy on the stand, both in direct and in cross-examination, and back to again in redirect and in recross. Mr. Murphy...
All right, but let's understand that if we can, Mr. Sullivan. That agency analysis would relate to a client using a third person, i.e. the agent, to further some solicitation for or receipt of attorney advice. That is, advice for legal matters or legal services. So it's not a freestanding agency, is it? It has to be an agency relationship relating to a particular either subject area or communication.
Well, the standard is whether the communication is within the scope of the agency relationship.
And the agency relationship, though, relates to some legal service or advice.
I think I see Your Honor's point. Not necessarily in the first instance. The scope question gets to the relationship to the legal advice. In other words, if Your Honor is asking whether the agent has to be part of some law firm or something like that.
No, what I'm looking at is whether or not you're arguing that any communications between Mr. Hernandez and Mr. Murphy would be privileged because he was Mr. Hernandez's sports agent.
I'm not. I'm not.
So when we talk about the first NFL draft and negotiating contracts and endorsements, you're not suggesting that an agency relationship would implicate the attorney-client privilege as to those activities.
Not necessarily, no. That's not my point with this.
So your point here is that if Mr. Hernandez communicated with Mr. Murphy about harassing or disturbing text from Bradley, that communication was to try and figure out how to deal with it from a legal point of view. and therefore the privilege would apply, I take it, at the earliest of those communications.
That is my argument precisely,
Okay.
that the second Mr. Hernandez provided Mr. Murphy with those text messages, with the pregnant question, well, what do I do? Then that was covered by the attorney-client privilege because, importantly, in Jensen, it was consistent with the scope of the agency or employee relationship. Jensen's a little broader. In Jensen, Your Honor, I think it's analogous. You had a non-lawyer nephew, and the court prevented this nephew from testifying about communications he observed between the uncle and the uncle's present when the nephew was there because when the nephew was present in his capacity as the uncle's agent. So Mr. Murphy testified that the pattern and practice of Athletes First is that they deal with every need of the client, from travel to hotels to NFL draft, endorsements, marketing, so forth, but also legal needs. And that's why they have a general counsel, and that's why they become part of legal teams, because he described it on the stand as a concierge service, a concierge service. So here, under the second instantiation of the potential attorney-client privilege relationship, representative of the client, by the very terms of Mass General Evidence rules, a representative of the client may be the client's agent or employee. He was his agent. And the may modifier points to the test, and the test is whether it's within the scope of the agency relationship. And we think that we have clearly met that burden given Mr. Murphy's clear and unequivocal testimony with respect to the scope of the relationship between his clients and his agency, and more specifically, Mr. Hernandez himself and the agency. The third area, Your Honor, is the attorney-client privilege may be present with respect to a representative of the attorney. That is to say, a representative of the attorney is also bound by the attorney-client privilege. And here again, under Mass General Evidence, Section 501A4, it states, quote, "A representative of the attorney is one used by the attorney to assist in providing professional legal services." In direct and cross-examination, we explored what Mr. Murphy understood his relationship to be to Ropes and Gray. He understood, he said several times, that he and Athletes First was part of a team, that they do not, in response to my very direct question, do not sort of pack up documents in a box and mail them to an attorney, but rather he himself, the general counsel of the firm, and whatever firm or whatever lawyer he might outsource to becomes part of a larger team.
As of when?
So the only difference between argument 2 and 3 is a temporal claim. I think that's what Your Honor is getting at. Under representative of client, the attorney-client privilege starts when Mr. Hernandez seeks legal advice by mailing, or I'm sorry, Your Honor, by emailing or texting the information. Under Theory 3, representative of the attorney, that relationship starts once Mr. Murphy reached out and Mr. Humanick reached out to Ropes and Gray and began discussing the substance of the case, which, as I understand from the testimony, was either that day or a day or two later. He made a phone call to his former colleague at Ropes and Gray in order to bring them in to assist with this effort.
All right, well, who makes someone a representative? If you're the representative of the attorney, would seem to me the attorney would have to make one, designate one, as you are now under the umbrella of my privilege with my client.
Well, the law is not explicit.
Well, think about it for a minute. I don't know if you're the representative of the attorney, that status could exist before the attorney grants it to you.
So I disagree, and I'll tell you why. So again, I don't think there's any there's no explicit statement in Massachusetts law. The thrust of the attorney-client privilege in Massachusetts is decidedly not an ode to some sort of stale formalism. That is, that there have to be these specific triggers or recitations that trigger the attorney-client privilege. But rather, as I read the law, it strikes me, Your Honor, as much more functional in its approach. That is to say, when certain things happen, the attorney-client privilege is present, not relying on, again, very formal structures. Now, if you take that, expand that notion to your question, when does someone assist? It would be when they begin behaving as if they are a team. So let's take the letter, for example. The letter clearly post-dated the meeting at Ropes and Gray. But again, it would be
let's look at the points in time. The points in time could be that letter, which is April 11 of 2013. The letter followed the meeting, so let's assume the meeting was some number of days before that. And then a third point in time is when a telephone call is made and arrangements are made to go see Ropes and Gray.
Yes.
Ropes and Gray have not accepted the case, nor has the client hired Ropes and Gray at that point in time, correct?
Correct.
It's merely going to be, well, come on in, let's see what we can work out. So your position is that that first telephone call triggers the attorney-client relationship under some functional approach?
Under a functional approach, yes, but there is clear doctrinal evidence in Massachusetts that there doesn't need to be a formal letter, there doesn't need to be a fee paid, there doesn't need to be a formal engagement, that coming to a lawyer seeking legal advice cements the attorney-client relationship. So that piece is factual and doctrinal, not sort of a theoretical functional approach to the law. So in answer to your Honor's question, that first call seeking legal advice on behalf of Mr. Hernandez, as Mr. Hernandez's agent, doctrinally cemented the attorney-client relationship. Everything else, the functional argument, again, pushes back against this notion that the letter somehow is a talisman.
Tell me when the cement is hardened. Is it at the meeting?
When the cement is hardened?
Yep.
We think it's quick dry cement, Your Honor. When the telephone call was made, then attorney-client privilege was established at that point. That's when the attorney-client privilege was established. Your Honor's correct. There are these several points of time where one can make arguments. The better argument, given the doctrine in the case, and I actually cite the leading case in my brief, and I'll just refer to it by reference here, so it won't take time looking for it, and the name doesn't come to mind immediately. But we cite it in our papers, Your Honor. So that piece is supported by doctrine, and it's consistent with what I've called a functional approach and not an overly formal approach in Massachusetts with respect to attorney-client relationship.
In the end, although I think it's proper to try and determine when a privilege, if it exists, first applies, in the end, it seems to me your position is it doesn't make any difference, because ultimately we're looking at a disclosure that is made after any of those points in time. That is, the disclosure being at the grand jury in March. correct?
Correct, Your Honor. And I'm sorry.
No?
I'd also point out that our view is that many minutes of testimony with respect to whether Mr. Murphy or Mr. Butters had somehow okayed these questions, we don't see how that is a relevant consideration. Mr. Hernandez was not represented there. It's his privilege and his privilege alone. We could even grant arguendo that they said, ask us anything. Ask us about the most private conversations that we have with Mr. Hernandez. That doesn't make it right. That does
No, I
not
get
waive
that.
the privilege.
Yep.
So I would ask Your Honor to not even consider those elements. So under any of the three theories, we think attorney-in-fact, representative of client, or representative of an attorney, we submit that a clear attorney-client privilege was made. It was made well before the grand jury testimony, and that by eliciting that in the grand jury and then relying on that same information as support for a search warrant, relied on information that was gained by piercing the attorney-client privilege.
Got it. Commonwealth?
Thank you, Your Honor. I think we can start with the easy one first. I think there's no evidence that Brian Murphy was Aaron Hernandez's lawyer. And I think any belief that Mr. Hernandez had, well, not on the record, is completely unreasonable. Murphy testified that he was not holding himself out as an attorney after 1999. So to claim that there is some sort of inherent attorney-client relationship between Murphy and Hernandez is not borne out by these facts. The next two categories are closer, and as Mr. Hagen testified, going into the grand jury, it was known that there was a relationship, that there was a defense team, that there was some sort of inclusion of Murphy with Ropes and Gray. We did not have the letter outlining, the unsigned letter outlining what that may have been at the time. It was not shared. But either way, I think the question is, regardless of what that relationship is, are these text messages between the defendant and his sports agent covered by the attorney-client privilege? And I think we look to, again, Section 502 in the Mass Guide to Evidence, but we need to read it in its full. The rule of the privilege and the scope of the privilege when it comes to a representative is between the client or the client's representative, so between the client, Aaron Hernandez, or the client's representative, Brian Murphy, and the client's attorney, Ropes and Gray, or the client or the attorney's representative. It does not create a freestanding privilege between the agent and the client. And that's where going into the grand jury and going
What do you mean the agent? Who is the agent?
the sports agent, Brian Murphy.
You mean Murphy as sports agent, as opposed to the other term we applied agent to is client's representative.
Correct. And standing alone, there is no privilege that protects a sports agent's conversations with the client. Now, taking the defense team view, and we didn't litigate it at the time, I'm not pushing that now, that it is his presence, the sports agent, Brian Murphy's presence, when the attorney and client, Ropes and Gray and Hernandez, are communicating. His presence does not destroy that privilege. We've taken that view from the beginning. We're not litigating that issue, and that's, again, why Mr. Hagen did not ask any questions about Ropes and Gray. The goal was not to implicate any conversations that Mr. Murphy may have been around between the lawyer, Ropes and Gray, and the client, Aaron Hernandez. We weren't interested in that information. We were interested in the information between Aaron Hernandez and the sports agent, which we had in text message form. That in and of itself is not protected. There is no umbrella to cover those conversations that were had outside of the presence of the attorney.
Why not?
Because the scope of the privilege does not cover those independent conversations. If Ropes and Gray had
Well,
been...
suppose Ropes and Gray says to Mr. Murphy, Brian, it's easier if you be the go-between between Mr. Hernandez and us. So we may on occasion ask you to obtain certain things or ask certain questions under the umbrella of the attorney-client relationship we have. Wouldn't then those subsequent actions be encompassed within the privilege?
Theoretically, yes. We have no evidence on that point. If Ropes and Gray had
So I'm
said...
told here, Ropes and Gray said, you know, we ought to have that phone or those texts. And isn't Mr. Hernandez's text a confirmation that I've complied with the request of the lawyers?
First, it's a confirmation that he made to a third party. And second, in Mr.
The
Hernandez's...
third party being
the agent.
Murphy.
Someone separate and apart from that relationship between attorney and client. But as a factual matter, I do think even if we look at Mr. Hernandez's affidavit, paragraph 4 states, based on the advice of Brian Murphy, I gave my cell phone to the law firm of Ropes and Gray. There's no evidence that the actions of Hernandez and Murphy's responses are at the direction of Ropes and Gray. In fact, this statement is to the contrary. It's, I called my sports agent for advice. My sports agent told me to do something. I did it. Those conversations do not fall within the attorney-client privilege. I think the key case on the derivative attorney-client privilege, this representative type, it's a Second Circuit case, I think is cited in both of the memoranda. But we interpret the privilege narrowly. This is not to be an expansive privilege that covers all communications between the representative, the agent, between Mr. Murphy and Mr. Hernandez. Their text messages as a whole, just as one category of communications, are not privileged. And I think it's telling that when presented with those messages in the grand jury, there was no objection. If I, as an attorney, sat down and somebody presented me text messages with a client, my first instinct, my first reaction would be, those are protected communications. I am an attorney, I have had a communication with a client, or I am a representative of an attorney, I have had a communication with a client. I think that matters, and those facts are telling. And as noted in the Commonwealth's opposition, we opposed the motion on the grounds that there was no attorney-client relationship or privilege, and then offered to go the step further that should this court find there's a privilege, I don't know that suppression is the remedy. I think the case law, I've begun to research that point, and I think if we needed to go further, we could. But again, there was no wrongdoing on the part of the Commonwealth. And so information that was contained in a search warrant was contained in a search warrant, and we get to this point. The Commonwealth's not seeking to elicit that testimony at trial. It's setting aside whether it's privileged for going forward and for testimonial purposes. It's simply a part of the affidavit, and it's I think, proper for that purpose. Absent a showing of egregious misconduct, which certainly is not the case here.
You don't think the appropriate remedy would be to redact that information from the affidavit?
Not without a showing of misconduct. No, I don't. I think that there needs to be some governmental wrongdoing. And the cases that I found on that, it's egregious government wrongdoing. Putting a camera into a lawyer's office, not in this jurisdiction, but in other places. And again, this is the kind of the second argument that hasn't been fully fleshed out. And it's fully dependent on this court finding, one, an attorney-client relationship, and then two, that the text messages are under the umbrella, are within the scope of that privilege, such that the Commonwealth never should have seen that Murphy communicated with Hernandez. Again, and that's we receive this information, and it's not readily apparent that it's between attorney and client. It's not apparent at all, it's not covered at all. Not to the Commonwealth, not to the prosecutors in Bristol County, and not to Brian Murphy when he's shown these text messages, or Attorney Butters when he's sitting there representing him. So I think my argument falls more on the scope than on the timing. I think the timing does matter. I don't know that it's particularly narrowed down here, where you have a series of text messages in April, you have an unsigned letter talking about representation from April, a meeting that happened at Ropes and Gray, presumably sometime between April and June, and then Odin Lloyd's death on June 17th of 2013 with the text messages the day before saying just drop the phone off. I don't know, again, my emphasis is on the scope and not on the timing, because I don't believe at any point there's a protected relationship that would cover, one, any communications between the defendant and Murphy, and two, not these conversations between the defendant and Murphy.
Okay. All right, I'll take that motion under advisement.
May I ask a question, Your Honor?
Yes, sir.
I should wait for an answer. There was one new issue raised about remedy that hasn't been briefed. Would Your Honor want briefing on that? I disagree with
Well, no,
everything
you
that you
told
just
me your view of the remedy is suppression.
made. Correct.
Commonwealth's telling me that's not necessarily the remedy.
And then,
So
and
it
that,
seems to me it's framed, and it certainly is something I would have to decide if I find
May
there
be
was a
heard on.
violation. Sure.
may be heard on remedy,
Yeah,
Your Honor.
absolutely.
So we disagree with the government's contention that any remedy outside of suppression is appropriate. And importantly, the entirety of the law in Massachusetts on attorney-client privilege makes crystal clear that the value that the privilege seeks to vindicate does not include or is sometimes antagonistic to things like the fact-finding and so forth. This privilege protects a different set of values, and that is the robust, unadulterated conversations between lawyers and clients. So this notion that there needs to be egregious error in order to remedy the attorney-client privilege, again, without having briefed it, I'm not aware of any authority in Massachusetts that makes the claim, at least in the way that counsel described it. But I'm happy at a moment's notice, Your Honor, to fully brief that issue.
All right. I don't intend to send you a notice. So if you want to brief
I will be a
it,
self-starter.
sit down at your typewriter, because I intend to start focusing on deciding this motion.
Very well.
All right. That motion is now under advisement. Let's take up our other motions. You folks ready to go forward? Does anyone need a break?
No, we're ready, Your Honor.
Okay. All right, I have 8 other defense motions and 1 Commonwealth motion. I have defendant's motion in limine for a special credibility instruction. As it relates to Mr. Bradley, Mr. Sullivan, it seems to me this is more appropriate as we consider final instructions.
Agreed, Your Honor.
So I'm denying it as premature. You certainly can advance it at the time of jury instructions.
Very well.
I have defendant's motion in limine to exclude evidence of a gun tattoo. Mr. Hagen, I don't know that I have a Commonwealth written response to that. The defendant's assertion is that this is simply irrelevant and quite prejudicial. How is the existence of a gun tattoo relevant in this case?
Right, this motion, as you know, was just filed last week. I believe Your Honor asked the parties to speak and decide which motions would be undertaken and argued. Obviously, the Commonwealth will want to submit a written response. We argued this motion extensively. It's an important piece of evidence. I think from our conversations with counsel, they had agreed that this would not be something that would be pressing to be heard today. I'm certainly willing to speak to it or discuss
Speak to it.
Well, Your Honor, essentially, the Commonwealth alleges that after the double homicide of Safira Furtado and Daniel Diabreu on July 16, 2012, that Mr. Hernandez and Mr. Bradley continued some relationship, eventually leading to Mr. Bradley being shot in the head by Mr. Hernandez on February 13th, the year 2013. The Commonwealth alleges in an effort by Mr. Hernandez to silence Mr. Bradley. The Commonwealth presented evidence to the grand jury and would expect to present evidence at trial that prior to February of 2013, Mr. Hernandez had numerous tattoos all over his body, all of which meant something important, including the death of his father, his nephew, his brother, where he's from, various things that are very important to him, his fiance. And that the Commonwealth has evidence that on or about late March, early April of 2013, Mr. Hernandez went to a tattoo parlor in Hermosa Beach, California. That Mr. Hernandez asked the tattoo artist.
That's when?
That's late March of 2013, or perhaps even April 1st. The exact date is not quite known. Mr. Hernandez asked the tattoo artist to give him a tattoo, specifically asking for the cylinder of a revolver, and asking that the cylinder of the revolver include one empty chamber, suggesting that the revolver had 5 live rounds. That's important because the Commonwealth will attempt to introduce evidence from ballistic evidence, a shooting reconstruction evidence expert, that in fact 5 rounds were fired by the defendant on July 16th, the year 2012, into the car that killed Daniel Diabreu and Safira Furtado. There's also 5 wounds to those decedents as well. Mr. Hernandez, at the same tattoo session, also asked the tattoo artist to tattoo the words, "God forgives," directly underneath the cylinder with the 5 live rounds of ammunition. The "God forgives" was also requested to be put backwards so that it could be viewed in a mirror. Additionally, at the same time, the tattoo artist was asked by Mr. Hernandez to give a tattoo of a semi-automatic handgun. With that semi-automatic handgun, he was asked to imprint a tattoo of one spent shell casing with smoke coming from it. It's important to note that
This is a separate tattoo.
a separate tattoo, but given at the same time. It's important to
And this is what? A pistol and
a semi-automatic pistol with one spent shell casing. Importantly, Alexander Bradley on February 13th, 2013 was shot with a semi-automatic 9mm handgun. The only piece of evidence that was recovered from the scene where Mr. Bradley's body, nearly deceased, was found included a semi-automatic shell casing, one casing. So the Commonwealth's suggestion is that the tattoos at issue, being both the cylinder, 5 rounds, deliberately asked for the 6th round to be empty and the words "God forgives," as well as a tattoo suggesting one shot from a semi-automatic revolver or semi-automatic handgun, is in fact an admission by Mr. Hernandez, in fact somewhat of a confession, particularly where he puts the word "God forgives" underneath. Commonwealth suggests that the probative value of this evidence strongly outweighs any prejudicial effect, and that's essentially the Commonwealth's argument. But again, Your Honor, we'd like an opportunity to brief this. I know there's been a recent case, Lamora Gray, that relates to rap videos. We suggest it's a completely different analysis here.
Sullivan?
So first, Your Honor, we would agree with counsel's representation that at the last hearing you asked us to go offline and talk to each other about what we consider to be most important. We just filed this, so we have no objection to, for its worth, have no objection to the government being able to file a written response. Briefly, if Your Honor wants representations, we're happy to make them with respect to.
Well, the written response, I take it, is going to tell me in legal terms what Mr. Hagen has just told me by way of proffer, that it was a tattoo or tattoos obtained at the end of March 2013. That's what, roughly 6 weeks after Mr. Bradley was shot. And that the defendant was particular in the types of tattoos that he wanted, including the language, the words written underneath the revolver. And the Commonwealth is saying this is introduced not as other evidence, but essentially as a visual admission in some evidence, I take it, of either an admission or a consciousness of guilt in each instance. Is that essentially what you're going to tell me in writing?
Yes, Your Honor.
All right, I think I got that. And so the Commonwealth's position is, if I understand it, these tattoos directly relate to the criminal conduct underlying the indictments here, as opposed to the Gray case where it was simply a freestanding gang video offered to show a defendant's membership in a gang, but having other connotations. And as the appellate court told us, we have to be sensitive to the cultural sensitivities of different groups and the way they express themselves musically. So I get that. I don't know that I need much more on this motion, but are you telling me you're not prepared to fully argue it now?
We can argue, yes, Your Honor, so we're happy to argue.
Yeah. Well, let me hear your view on it.
All right, so, Your Honor, we have at least 3 objections to the argument. The first is on relevance grounds, that the tattoos in question are not relevant. Second, to the extent the court finds them relevant, they are unduly prejudicial and should be excluded on that basis. And third, Your Honor, and the third is probably more likely a motion a little closer to trial, or maybe subject to an objection a little closer to trial. But the third is that there's no, the government will not be able to lay a foundation sufficient to justify the admission of the evidence. Now, first to the relevance, in Your Honor's colloquy with Mr. Hagen, it's even those representations are unclear. That is to say, the relevance of a revolver in a case where presumably they're saying their theory, the Commonwealth's theory, is that the shooter, whoever the shooter was, used some other type of weapon. Not sure of the relevance of the revolver in the first place, how the government intends to tie these things together. In any event, I should say, the concept of relevance, as Your Honor knows, is now bound up with materiality. So things can't just have a general influence, but they have to be material. They have to be related to some central fact in the litigation. And here, this is under the sort of old vocabulary, this is a materiality objection as well. Were the court to find the evidence both material and both relevant and material, it's unduly prejudicial, and that's why we included some of the doctrine with respect to the rap music and the way in which courts have to deal with cultural particularities. That people get tattoos, and some people get a tattoo with a gun on them, does not mean that the Commonwealth is allowed to pile inference on top of inference on top of inference to get to a point that suggests that this is an admission. Now, a admission, presumably that theory is an admission as some sort of legally operative fact, as some sort of non-communicative, non-testimonial type admission. Now, if there were a tattoo, obviously, that read, that read something like, I'm responsible for this, or I'm responsible for that, then perhaps that would fall under a reasonable definition of admission. But what they're suggesting is to take something that is legal, on its face, getting a tattoo, two presumably unrelated pictures, and a sentence, God forbids, and to construct a narrative
It was
around those three.
Forgive.
I'm sorry.
Right? Forgive,
God forgives.
not forbid. Forgive.
Oh, did I say forbids?
Yeah.
I'm sorry, forgives is what I intended to say. That God forbids is, I said it again, forgives, apologies, Your Honor, is stretches the meaning too far. It invites the very sorts of inferences that Your Honor is charged with protecting the jury from. The third aspect, Your Honor, has to do with notions of foundation, and at least we've not heard yet a sufficient proffer about how the government intends to prove all of this up, absent the sort of rank speculation that is disallowed in these sorts of areas.
Well, I assume we're going to hear the tattoo artist on the witness stand saying, that's who I gave a tattoo, and this is what he asked for. I can't imagine how else it would be admissible, how else the Commonwealth would lay the foundation.
And absent that tattoo artist saying something like, a client came in and said, well, I really feel guilty about something that happened in Florida. Can you commemorate this? Then it becomes an invitation to the sort of speculation that is unduly prejudicial and violates Mr. Hernandez's rights, both under evidentiary law and with respect to his right to a fair trial. And so it raises a constitutional concern as well. Court's brief indulgence.
Your Honor, if I could make one factual clarification. The decedents, Mr. D'Abreu and Mr. Furtado, were killed with a revolver.
All right. Motion's under advisement.
And may I say one other thing, Your Honor?
Yes, sir.
And so with respect to, we're not sure how Mr. Braille was killed, Your Honor. I mean, that's something that we are highly contesting. Certainly wasn't killed by Mr. Hernandez, but we know it's a firearm, and that's subject to motions that you have there with respect to
Yeah.
the forensics.
Well, are you challenging that he was shot to death?
No, but
So we know he
what-
was killed with a firearm. The question is what type?
Correct, Your Honor.
Okay.
Yes.
Yep. All right, that motion's under advisement. Defendant's motion in limine to exclude mention of the defendant's prior conviction in the Lloyd case.
Your Honor, may I address the court?
Yes,
These
sir.
motions. We have had conversations with the prosecution and internally about what motions we're going to ask to be heard today, pursuant to what the court told us to do last week. And really the only other, there's a couple of minor motions, the III records, which I think the prosecution has agreed to produce. Am I right about that, Mr. Hagen?
That's correct.
And there's another motion that we haven't agreed to. We have a motion with respect to a view and for request by the court to order certain records from the cure that I believe we're in agreement on. And is that true?
Essentially, we can go through the paragraphs of the representations.
Yeah. So the other motions, Your Honor, with respect to the relief on tangible evidence, both with respect to the car or the video, or with respect to the Odin Lloyd matter, we didn't intend to take these up today. I don't counsel for the...
You know, it's fine. I'll be happy to table them.
Yes.
But what I don't ever want to hear is we're surprised by a late decision of the court. We filed this motion back in God knows when, and there was no ruling.
No,
If
we
the
just
parties
filed.
by agreement
Yeah.
want to defer ruling on some of the motions, that's fine, so long as you understand the decision when issued is issued at that time because of your request to delay, your table.
I mean, we're not looking for much, Judge. I mean, next week, we're happy to argue if the court's calendar is sufficient.
No, we start trials next week, so we're going to get very busy. But I'll be happy to put that motion off at the party's request. The next motion I have is the motion to view the Cure Lounge and for production of documentary evidence. Now let me ask whether, and just so we're clear, Mr. Leontier, this motion had been filed, I think, last week, and is supplemented or replaced today with a new motion?
Yes, Your Honor.
Essentially the same thing, but revised in some way.
A little bit clearer in an affidavit.
Can I throw out the other one?
You may.
All right. Have you all discussed this motion and whether or not any arrangements could be made to inspect the interior of Cure Lounge? Is that something the Commonwealth's looking to do?
Yes, Your Honor, I've spoken to representatives of Club Cure. They have advised me that they will make the Club Cure available at defense counsel's request and the court's request, which I believe right now defense counsel is asking for next week, January 4th. They will make the area available. They will also agree to allow experts from the defense to inspect any video that's existing, as well as the equipment. They've also agreed to do a diligent search to determine whether or not they can comply with the other requests, including the records of repair or analysis of the video that's been sought. So essentially, everything that's been asked for, if it exists, has been agreed to by Club Cure.
Will that representative of Club Cure be available next week?
The representative that Club Cure indicates would be the best person to answer any and all questions is the man by the name of Zaid Zabulsi, Zabulsi, and I am told that he can be available at some point next week. He has not been made aware of the January 4th date, however, so I do need to check with him.
Is that acceptable?
Yes, totally acceptable, Your Honor. We just would like an order, though, to this effect, just to ensure that they produce what they've asked them to produce.
Well, I don't know that I can issue an order without giving them an opportunity to be heard.
Okay. The rule provides for 7 days notice, Your Honor.
Yeah.
If we notice them today, then they've got 7 days to come in to object, which is before the 4th.
Mr. Leontier, I think what I'd prefer
Okay.
is to take no action on the motion based on what I understand to be an agreement that there will be an inspection next week with access to the machine or the devices and a representative available. And if you find that that has not been satisfactory to your needs, then I'd be happy to schedule a very prompt hearing thereafter and fit you in some afternoon. It's a way of saying, let's bring you all back only if necessary, as opposed to bringing Cure in next week for
Well, they
what
don't have
may
to
be
come in.
unnecessary.
They don't have to come in on an order, only if they wanted to quash. But it's okay.
Well, it's not to quash, it's before issuance under Lampron, I have to give them an opportunity to be heard.
Right. And if they don't show up to be heard, but that's fine.
Yeah.
Your Honor, I just want to make clear one thing. We've also asked for documents here, and the reason we have is because the equipment that may have been there in 2012, we have information that it is no longer available. So in order for us to understand the nature of the equipment that was there, we've asked them to produce pursuant to the requests in the motion there are 4 requests, specific kinds of documents. I just want to make sure it's just not to view and look at the equipment, but I think Mr. Hagen has said that they've agreed to produce whatever records they have. Is that correct, Mr. Hagen?
That's correct.
All right.
Okay.
All right, have your inspection. You've got someone lined up to look at this stuff next week?
We have an expert, you know.
And will you also be seeking to, yes, you will, take measurements, photographs and whatnot inside?
Yes, sir.
Uh,
And examine the equipment forensically and otherwise.
All right. I have your motion for relief based on the loss of tangible evidence, that is, video surveillance of the interior of your lounge. Is it more appropriate to take this up after your inspection?
Absolutely, Judge. That was our anticipation to request an evidentiary hearing, depending on what takes place.
And Mr. Hagen, what is your understanding with regard to interior surveillance? The equipment wasn't working, or they don't record and preserve?
They do record and preserve. It's the indication that at least has been provided by at least perhaps 2 representatives of Pure that the equipment was malfunctioning at the time and downstairs, and those videos did not record.
Did any of the interior record?
Yes, the interior lobby area, the cameras outside, and the camera that shows the identifications that are shown by patrons as they But I know there is a live issue for the defense as to whether or not the police requested the video in a timely fashion, and whether or not the video was overwritten or the cameras did not work. That's a live issue.
Judge, just if I may add.
Yeah.
There were 9 cameras upstairs, 3 in the lobby, and approximately 6, maybe 9, maybe 8. Apparently, all those cameras worked. There are 8 cameras downstairs, and allegedly none of those cameras work. And that is the issue that we need to go look at.
Okay. Does the Commonwealth intend to be present next week?
Yes.
All right, what are the motions that you all contemplate taking up today?
We have a very small one, quick one, I think, which is motion in limine to obtain certain victim witness passport information for 4 individuals. Your Honor, as you know, the Commonwealth has agreed to provide us with the Corey reports and the III reports. 4 of the witnesses were from out of the country until fairly recently. We are seeking to do, as we do with all the witnesses, investigatory backgrounds, and without this information, it is very difficult for us to do any investigation.
This is your motion for passport information
Yes, Your Honor.
as to 5 individuals.
I'm sorry, 5.
Commonwealth?
Your Honor, we respectfully object. We have absolutely no control over passport information as a federal government function by Immigration's Customs Enforcement. And counsel is certainly free to file what I believe would not even be Rule 17, but instead what they refer to as a 2E letter, I believe, to the United States Attorney's Office that would, I believe, represent the federal agency of ICE, which would then begin the process of seeing if they are willing to answer the request and what documentation, if any, they can provide.
Your Honor, quick, may I speak quickly on this?
Yes.
The Commonwealth does in fact communicate with Immigration and Naturalization Services. In fact, in this case, they have a agreement with INS with respect to one of the witnesses they intend to call. So I don't think it's out of the realm for the Commonwealth to inquire either of the witnesses themselves or the families or INS with respect to passport information. I mean, virtually impossible to do background checks when someone doesn't have a history here that we can examine.
All right, the motion is allowed to the extent the Commonwealth has possession, custody, or control of passport pages. Under Commonwealth versus Beal, the Commonwealth has no independent duty to have to get that information. What other motions today?
Your Honor, we addressed last time, there was an earlier motion on the production of information on experts,
Yep.
forensics and experts. We've been working with the Commonwealth. We seem to have agreement with respect to that motion, but we still don't have information on 3, 6, 7, 8, 10 significant requests. We would just, and I don't know if Mr. Hagen will object to this, we would just request that an order be issued because we need to ensure that in fact this forensic material is provided. I can go through each paragraph that the information is we don't have, but this has been an outstanding motion for a while now, and I know they've been working in good faith with Linda Kenny-Batten on this issue, but we would like to proceed with an order here, and I would expect that hopefully we'll get all the information and then we can just put that issue aside.
All right.
Your Honor, we would ask that in order not issue, we have specific information. I believe some wires may have been crossed, but we've had extensive conversations with Ms. Kenny-Batten.
Well, I've heard this now on 2 previous hearings, that you're all working towards some resolution. Mr. Hagen, you still feel you're working towards a resolution?
I do, and I feel we're very close.
And Mr. Leontier, Ms. Baden does not feel
She
it's
does
going
not,
forward.
she does not, Your Honor. The only information that she said we've essentially received to date are the police manuals. And with respect to detailed information, we think we're on track with respect to dropping it down from 10 years to 5 years. We've agreed with that. I think the Commonwealth wanted us to do that. But we still have no information. And, you know, the clock is running here.
All right. Which ones?
I'll give you specifics. With respect to 5, 6, 7, 9, 10, E, G, and H, 14, and 15.
Well, 10,
E, G, and H.
okay.
14
What?
and 15.
As a preliminary matter, and I
15?
15, yes. 14 and 15 under this.
All right. Anything else?
No, Your Honor.
as a preliminary matter, and Mr. Leontier was not part of these conversations, unfortunately, but in our conversations with Ms. Kenny-Batten, we requested whether or not the information sought would also be relevant to the Massachusetts State Police, where they conducted only 3 tests, all of which were negative. Ms. Kenny-Batten, again, indicated she had to discuss it, but that she was inclined to not be requesting all this information relative to the Massachusetts State Police Crime Laboratory. We also inquired of Ms. Kenny-Batten, I believe Mr. Byers was on the phone as well during this conversation, whether or not this would include the medical examiner's office and some other entities that did work. And she suggested that she would be filing separate motions in regard to that, and that would not apply to the motion filed here. I don't know what the panel counsel's position is on that.
In my discussions with Attorney Batten.
Where is Attorney Baden?
In New York.
And she is the one you've been negotiating this with.
Correct.
I've been,
Up here.